Rape Charges and Consent Laws in New York by attorney Andrew M. Stengel. There are 3 degrees of rape charges in New York: rape in the first, second, and third degrees. Rape charges in New York and other states concern allegations of sexual intercourse by forcible compulsion or an incapacity to consent. The degree of the rape charge mainly involves 2 factors: the age of the complaining witness and/or person who is charged, and/or the status of the complaining witness and the person who is charged. All 3 degrees of rape are classified as felony crimes in New York. Forcible compulsion and rape allegations. New York law defines forcible compulsion, which applies to rape charges and other sex crimes. Under New York's penal law, forcible compulsion means the use of physical force or an express or implied threat that places a person in fear of immediate death or physical injury to himself, herself, or another person, or in fear that he, she, or another person will immediately be kidnapped. The question of forcible compulsion is often a fact-specific question and depends on the nature of a person's alleged acts and/or the words that a person allegedly used. Incapacity to consent in rape allegations. In New York, there are 10 categories listed in the state's penal law where a person cannot legally consent to sexual intercourse. If a person falls under any of these 10 categories, then he or she is deemed incapable of consenting to sexual intercourse and other sexual acts. The most common categories of an incapacity to consent are if a person is less than 17 years old, which is New York's age of consent, mentally disabled, has a mental illness, mentally incapacitated, is in a temporary state due to a drug or intoxicating substance given without consent, physically helpless, is unconscious or physically unable to communicate an unwillingness. Some of the other 10 categories where there is an incapacity to consent to sexual acts include a person who is detained or in the custody of police, and the accused is either detaining or maintaining custody, committed to a state or local prison or jail, and the accused is an employee, a person who performs certain professional services, or a volunteer, committed to a residence by the State Office of Children and Family Services, and the accused is an employee, a person who performs certain professional services or provides direct supervision, a client or patient, and the accused is a healthcare provider or mental health care provider, and the alleged act occurs during a treatment session, consultation, interview, or examination. Former New York prosecutor Andrew M. Stengel is an experienced and knowledgeable rape and sex crimes lawyer. Andrew M. Stengel is a skilled trial attorney, a diligent investigator, and a tenacious representative. Whether the charges involve rape or any other criminal charge or investigation, Andrew M. Stengel provides skilled and vigorous legal advice and representation. For more information, visit the website of Andrew M. Stengel, www.stengellaw.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.